Hi everyone, thanks for coming to this meeting today. So today's session will be on data security and rights. I'll allow Pascal to introduce himself and we can just start the meeting and people will join as it goes. Thanks again for your attendance. I think we can start. Pascal, you can introduce yourself and begin.
Hi guys, my name is Pascal Mudimba. I'm an economics and statistics student in KU, Kenyatta University. I started developing blockchain systems in 2016 with IBM, Digital Nation Africa. And then my statistics journey in school got me into data science. That pushed me through to ML, that is machine learning. And I've been building machine learning models for 4 years now. But all that now got me wondering if this career is viable enough for me to go on without without knowing the basics, data and stuff like that. So I got into cybersecurity, and my niche was physical security. But I got to grow as I stayed in cybersec. I got to grow and I got to love data security and data rights. So I've been a pioneer for data rights since 2019, and that has got me here. So I was born, that's my story, now I'm here. So we'll go straight into it and get to know some nitty-gritties about data and its values. So we all know security is a key consideration for any business continuity and disaster recovery strategy, that is the BCDR. And with data, there are three main principles that are supposed to be considered when working with data, known as the CIA Triad. It's a security model that consists of three vital information security principles, that is confidentiality, integrity, and availability. Firms and companies they used to be requested to enforce the CIA Triad, but right now in Kenya, now that the GDPR laws are in effect, they won't really request you. It's a must that you have to enforce these laws and maintain these practices, like data being handled based on the organization's required privacy. An organization needs to set up policies that protect the privacy of people, like people's data, that is, by using encryptions and two-factor authentications. There should be a couple of layers of security to protect people's data. We should keep access control lists and other file permissions up to date. That is what will keep data available, as in data will be confidential if there's good encryption. It will be available if it is up to date, and it is of integrity if it is handled based on the organization required privacy. Like there's a chain of command whenever data is being handled. The right person is handling the right kind of data. So the CIA Triad goal of confidentiality is more important than the other goals when the value of the information depends on limiting access to it. Like information confidentiality is more important than integrity or availability in case of proprietary information of a company. You can't just give your company's data out there because it is needed in a timely manner or something like that. So data protection has some principles, and I'll use the Data Protection Act via Kenya that was implemented a few weeks ago. The Act requires data controllers and processors to process data lawfully, minimize collection of data, and it restricts further processing of data. It requires data controllers and processors to ensure data quality and that they establish and maintain security safeguards to protect personal data. The Act requires that any person who acts as a data controller or data processor must be registered with the Data Commissioner. Therefore, once the office of the Data Commissioner is established, which it already was, organizations meeting the definition of a controller or processor will need to register as such and renew their registration every 3 years. So transfer of personal data outside Kenya. Every data controller or data processor is required to ensure the storage on a server or data center located in Kenya of at least one serving copy of personal data to which the Act applies. Then there's cross-border processing of sensitive personal data is prohibited and only allowed when certain conditions are met under certain circumstances specified by the Act, Part 4, from 48 to 50. A data controller or data processor may transfer personal data to another country where the data controller or data processor has given proof to the data commissioner on the appropriate safeguards which respect the security and protection of the personal data. The data subject has given explicit consent. The data subject should have given explicit consent to the proposed transfer after having been informed of the possible risk of the transfer, such as the absence of appropriate security safeguards. The transfer is necessary for performance of a contract, or the transfer is necessary for the performance of a contract. Oh, hold up. So when you're transferring personal data outside Kenya, and you're a data controller or a data processor, you are required to ensure the storage on a server and data center located in Kenya of at least one serving copy of personal data to which the Act applies. So I'm reading that. I have this for you to read because I want you to flow with me too. So the exemptions to processing of personal data from provisions of the Protection Act, like if it is necessary for national security or public order, we can't have terrorists like Al-Shabaab communicating and the government can't maneuver the systems and get to know that these people are communicating. Like the government has a right to go into their data and know, let's say, their locations, their faces, their fingerprints. So when disclosure is required by or under any written law or by an order of the court, like the anti-money laundering laws, when the provision or detection of crime, like the anti-money laundering laws, and the apprehension or prosecution of an offender, or the assessment or collection of a tax or duty or an imposition of a similar nature. The apprehension or prosecution of an offender, the assessment or collection of tax or duty, I've gone through that too. So what are recent developments in the data protection sphere in Kenya? Like a few months ago, I can say it's a year now, the Immaculate Kasait was recruited as the data commissioner to head the office of the data protection commissioner in October 2020, that is, and subsequent vetting by parliament, and she was appointed, sworn in as the data commissioner. On 15th January 2021, there was an appointment of a 14-member task force chaired by Immaculate Kasai to review the Act, identify gaps or inconsistencies in the law, propose any new policy, legal and institutional framework that may be needed to implement the Act, develop the data protection regulations, and train stakeholders and public on the said regulations. On 24th February 2021, the Ministry of ICT Permanent Secretary Esther Kolmet launched the Office of the Data Protection Commissioner official website and draft guidance notes of complaints management and server charter. On this website, you can also get to report any data breaches, as well as on the National KESAT website. On 17 February 2022, the 3 data protection regulations published in Kenya Gazette by the Cabinet Secretary Joe Musheru, the Ministry of ICT Cabinet Secretary Joe Musheru were passed by Parliament. So you can access the regulations at the Office of the Data Protection website, that is the odpc.go.ke. So there are key elements of the Data Protection Act, and I'll just go through them one by one. So the first one is penalties for non-compliance. Infringement of provisions of Kenya Data Protection Act will attract a penalty of not more than 5 million Kenyan shillings, or the case of an undertaking, not more than 1% of its annual turnover of the preceding financial year. Whichever is lower, individuals will be liable to a fine not exceeding 3 million shillings or to an imprisonment term not exceeding 10 years or even both. There'll be an increased territorial scope. The data protection will apply to all companies processing the personal data of data subjects residing in Kenya, regardless of the company's location. There'll be explicit and retractable consent from data subjects. Consent must be provided in an intelligible and easily accessible form, using clear and plain language. It must be easy to withdraw consent as it is to give it. There will be data subject rights, which we will look into in a few. Data subjects can request confirmation whether or not their personal data is being processed, where and for what purpose. Additionally, data subjects can request to be forgotten, that is the right to deletion, and which entails the removal of all the data related to the data subject. Then whenever there's a breach, you as the data subject, you are supposed to be notified within 72 hours. But the data commissioner is supposed to be notified within 72 hours. Same to the data subject of becoming aware of a breach, and to the data subject in writing within a reasonably practical period. 72 hours is reasonably practical. So there should be privacy by design. Now, a legal requirement for the consideration and inclusion of data protection from the onset of the designing of systems rather than a retrospective addition. A data inventory is required in every data controller and data processor firm. Organizations must maintain a record of processing activities under its responsibility, or in short, they must keep an inventory of all personal data processed. The inventory must include the multiple types of information, such as the purpose of the processing. There should be mandatory data protection officers. Depending on the type of personal data and intensity of processing activities, an organization may be required to appoint a data protection officer to facilitate the need to demonstrate compliance of the Act. So the implementation of this Data Protection Act will have some impact on some organizations. I will look into 3 organizations that will be of interest to you guys, that is legal and compliance, technology, and data industries. So for legal and compliance, the Data Protection Act introduces new requirements and challenges for legal and compliance functions. Many organizations will require a data protection officer who will have a key role in ensuring compliance. If the Data Protection Act is not complied with, the organizations will face the heaviest fines yet, up to 2% of the previous year's turnover. A renewed emphasis on organizational accountability will demand proactive, robust privacy governance. This will require organizations to review how they write privacy policies to make this easier to understand and enforce compliance. So chief risk and compliance officers, legal officers, privacy officers, and data protection officers. Your privacy strategies, resourcing, and organizational controls will need to be revised, and boardrooms will need to engage more than ever before. See, serious non-compliance could result in fines up to 5 million shillings, or in the case of an undertaking, up to 1% of the annual turnover of the preceding financial year. We've talked about that. So enforcement action will extend to other countries where analysis on Kenyan citizens is performed. But how will this play out? We'll look into this in a few. So there will be significant new requirements around maintenance of audit trials and data journeys. The focus is on organizations having a more proactive and comprehensive view of their data and being able to demonstrate they are compliant with the Data Protection Act requirements. These organizations processing personal data on a large scale will now be required to appoint an independent, adequately qualified data protection officer. This will present a challenge of many medium to large organizations as individuals with sought after skills and experience and that are currently short in supply. Organizations should now consider carefully how they construct their public-facing privacy policies to provide more detailed information. However, it will no longer be good enough to hide behind pages or legalese. In addition, the Data Protection Act will retain the notion of consent as one of the conditions for lawful processing, with organizations required to obtain freely given specific, informed, and unambiguous consent while being able to demonstrate these criteria having been met. So in technology, where there are chief information officers, chief technology officers, and chief information security officers, the new Data Protection Act requirements will mean changes to the ways in which technologies are designed and managed. Documented data protection impact assessments will be required to deploy major new systems and technologies that are likely to result in high risk to the rights and freedoms of data subjects. Security breaches will have to be notified to regulators within 72 hours, meaning implementation of the new or enhanced data security approaches and incident response procedures. The concept of privacy now becomes enshrined in law, with the privacy impact assessment expected to be commonplace across organizations over the next few years. An organization will be expected to look more into data masking, pseudonymization, and encryption. Significant data breaches will now have to be reported to regulators and, in some circumstances, also to the individuals impacted. This means organizations will have to urgently revise their incident management procedures and consider processes for regularly testing, assessing, and evaluating their end-to-end incident management processes. Individuals will have new rights to opt out and object to online profiling and tracking, significantly impacting direct-to-consumer business, who rely on such techniques to better understand their customers. The automatic decision-making on issues affecting the privacy or dignity of data subjects is also now regulated. This applies to just to website platforms, but also to other digital assets such as mobile apps, wearable devices, and emerging technologies. The Data Protection Act formally recognizes the privacy benefits of encryption. In case of a data breach where encryption safeguard was adopted, the law exempts the data controller or processor from notifying affected data subjects. However, this does not mean that organizations can afford to be complacent, and the exemption may not apply when weak encryption has been used. Given the potential fines, organizations will have to further increase their focus on a robust information and cybersecurity regime. The concept of privacy by design and by default, which is called the PBD, is nothing new, but now is enshrined in the Data Protection Act. Organizations need to build a mindset that has privacy at the forefront and of the design, build, and the deployment of new technologies, and in their business as usual operations. One demonstration of the PBD is a data protection impact assessment, which is now required to be undertaken for new uses of personal data where the risk to individual is high. So in the data industry, these are chief data officers, data stewards, chief marketing officers, and digital leads. Your information management activities have always supported privacy initiatives, but under the Data Protection Act, new activities are required, which specifically link to compliance demands. So identifying and tracking of data, organizations will have to take steps to demonstrate they know what data they hold, where it is stored, and who it is shared with. By creating and maintaining an inventory of data processing activities, data leads will have to work closely with privacy colleagues to ensure all necessary bases are covered. A thorough system for maintaining inventories needs to be implemented too. So a new right to data portability means that individuals are entitled to request copies of their data in a readable and standardized format. The interpretation of this requirement is debatable though, but taken broadly, the challenges could be numerous. Amongst them, achieving clarity on which data needs to be provided, extracting data efficiently, and providing data in an industry standardized form. So you also have the right to deletion, like right to be forgotten, a stronger right for consumers to request deletion of their data. A new right to be forgotten is further evidence of the consumer being in the driving seat when it comes to use of their data. Depending on regulatory interpretation, organizations may need to perform wholesale reviews of processes, system architecture, and third-party data access controls. In addition, archive media may also need to be reviewed and data deleted. The Data Protection Act expressly recognizes the concept of pseudonymization of data and places emphasis on data classification and governance, but it remains unclear if and when certain data will be classified as personal data and subject to requirements. So what are the approaches to take, actions to take to prepare for the Data Protection Act and other regulations that might come in? So based on a comprehensive Data Protection Act readiness roadmap, a tailored transformation program helps organizations prepare in the optimal way for the data protection regulation. So there's data protection, privacy, impact assessment, data processing inventory, third-party procedures, data protection and privacy transformation programs, and privacy by design. You also have to set up a good strategy, a strong starting point determining high-level direction and risk appetite upon which the organization builds its privacy organization. There is organization and accountability. Enabling effective implementation of the privacy strategy requires a strong and multidisciplinary privacy organizational structure. This covers the structure of the privacy organization as well as the role and position of key players, such as the data protection officer. This layer also covers accountability and how to prove compliance. So there are policies and procedures, there is data management and data transfers. Partnering with the business to ensure data is protected, governed, managed, and utilized effectively in line with the organization strategy also covers technological challenges such as data access, requests, data retention, rights to be forgotten, breach notification, and international and third-party data transfers. Communicating, training, and awareness, creating a high level of organizational awareness on privacy ensures that the organization's employees know and follow the rules. Embedding privacy into the organization's project methodology. This is done by efficient and practical guidance during conception of a new or changed product or service, as well as assessing new and existing systems following the established privacy impact assessment method. It also covers audit guidance and readiness for certification programs and adherence to code of practice in data protection and privacy. So a processing inventory is a fundamental element of any privacy program and will be a mandatory requirement following the Data Protection Act. So the data rights will go through some data rights like the data subject's right of access. You can reach out to your company. You can reach out to your company, to the company that you gave rights to your data and ask to access them. The data subject's right to rectification. If you gave out wrong data, you can rectify and correct the information. The previously mentioned right to erasure or right to be forgotten. The data subject right to restriction of processing. Like you can give your data to a data processor, but you can also restrict them from processing it and using it in a way that you wouldn't want it to be used. The right to be informed. You have a right to be informed of anything that's happening to your data, it being processed and where it's stored, how it is stored, and how secure it is. The right to data portability that is very debatable. The GDPR Article 21 of the United Kingdom is also about the data subject right to object. So it has not been touched in the Kenyan Data Protection Act, but you can object the data that is being stored without sorry, you can object the data in UK, but you can't object the data in Kenya. In Kenya, you can just rectify it. The data subject's right not to be subject to a decision based solely on automated processing. You can object process data, let's say an artificial intelligence algorithm, a machine learning algorithm that uses your facial contours and facial recognition data to decide that you're a criminal or you're the one being sought out by the Director of Criminal Investigations. You have the right to defend yourself and say that the machine learning algorithm was wrong. So there are responsibilities that data controllers should put in place. Like if you're a data controller, that means you decide to collect the personal information of your customers, site visitors, and other targets. So you must have legal authority to do so. You decide what to collect and when to collect it. You decide to change or modify the data that you get. You decide where and how to use the data and towards what purpose. You decide whether to keep the data in-house or to share it with third parties. You also figure out whom to share the data with. You decide how long the data is kept and when to dispose of it. So you've noticed that the subject has rights, but controllers and processors have responsibilities. So data processor responsibility, a data processor is the one who carries out the actual processing of the data under the specific instructions of the data controller. You are the data processor if you are instructed or tasked by a data controller to perform some of the following: design, create, and implement IT processes and systems that will enable the data controller to gather personal data. You use tools and strategies to gather personal data. You implement security measures that will safeguard personal data, and you store personal data gathered by the data controller. You transfer data from data controllers to another organization and vice versa. So that is it from me. I'll be expecting questions from you guys. I think I've saved a hell lot of time. I've been sharing my screen for 50 minutes, but we are 35 minutes into the meeting, and before I share my contacts, I'd just like any questions from you guys if you have any. And if you didn't get anything, I wouldn't mind to peruse and go through whatever it is that you didn't get.
If you have any questions, you can just drop a comment in the chat. You can just unmute.
So I'll just keep my line open and mic open until 8. So in case there's anyone who still has a question until then, I'm just here and ready to answer it.
Any questions, guys? Okay. Okay, if there are no any questions, I think what we'll do, Pascal, I think you can share the slides with me, then I'll forward them to the Shihax Telegram group and the other group in WhatsApp. Yeah, and I think people can access the materials there.
Hi, Tony. You're not very clear. Kindly come up.
What about now?
Yeah, I can get you. What are you saying?
Okay, thank you. So I was saying you can share with me the materials in my WhatsApp, then I can share them to the other Shiax members on the Telegram group, and also the various Shiax WhatsApp group that are there.
Okay, so.
Yeah, Nancy, I think she joined the meeting, but I don't think she's in a position to unmute. So it was a great session. Thanks everyone for joining. And I think we meet again on Thursday for the community sessions. Then we'll have another campus sessions on Tuesday. So thanks everyone for joining. Have a good night.
Okay, thanks, guys.
Okay. For those who wish to reach Pascal, I think you can see his contact on the screen.
Yeah, sir.